Good morning. Good morning.
Good morning, Judge.
Okay, so a couple of quick things. One, I note I've started pretty routinely at the beginning of these hearings getting notices that someone is using AI to take down meeting notes. Perfectly fine with me. Just want to make sure everybody's aware that's not any sort of official court record. It's just notes for you to use about what happened. Same to the point of this hearing itself will be live streamed, and there is certainly a recording that ends up on my YouTube page, which is a sentence I never thought I would say. But nonetheless, it is there and it does exist. It can be used as a reference point, but just a reminder, it is not an official record of any transcript or of any court action here. So just a reminder of that. Okay, we're going to get through this really quickly. First position I have is Holcomb's Crossing Homeowners Association versus Felicia Stanton.
Good morning, Your Honor. Frank Buddy for the plaintiff.
Okay, Mr. Buddy. Mr. Buddy, have you been in contact with Miss Stanton? Or yeah, Stanton.
From her from time to time, yes, Your Honor. There's no answer filed, but I believe that she has reached out to her firm at least a couple occasions since the case.
Okay. The only reason I ask is that I believe that she has tried to call our office a number of times this morning. Mr. Freehoff, I don't know what contact you have for Miss Stanton, but if you do have any contact, or maybe connect with our office and see if she's left a message, or perhaps I just want to make sure that she's not trying to access the Zoom and is unable to do so.
Judge, I spoke with her.
Okay.
She simply wanted my email address. She did not
Okay.
mention having any technical issues or requesting the Zoom hearing.
Excellent. Thank you. Citibank versus Sotero Lopez. Is anyone here on behalf of Citibank? Mr. Lopez?
Yes, I'm here.
Yes, sir. I see you there. So we are going to wait. If you can sit tight while I conduct the hearing to see if anyone is going to appear on behalf of Citibank. And if no one does, then I'll go in. I'll deal with that when it happens. Okay.
Okay.
Thank you, Mr. Lopez.
Thank you.
Lakeside at Crabapple Community Association versus Nanagua Capital. I'm sure I mispronounced that. Sorry. Anyone here on behalf of Lakeside at Crabapple? Anyone here on behalf of Nanagua Capital?
A review of eFile Georgia, Judge, shows that they did open the notice. So
Okay. Thank you. Villages of East Point versus Raymond Bell.
Good morning, Your Honor. Diana Swain on behalf of the plaintiff.
Okay, Ms. Swain, and have you heard from Mr. Bell, or were you expecting Mr. Bell's appearance today by any chance?
No, we do not expect that, but I do have two witnesses to testify today.
Okay, excellent, Ms. Swain. Thank you. Bridgestone Subdivision Homeowners Association versus Mark Calloway.
Morning, Your Honor. Mark Moore on behalf of the plaintiff.
Okay. And had you had any contact with or expected appearance by Mark Calloway?
We've had no contact whatsoever.
Okay, thank you, sir. Sheriff Labatt versus Augustin DeVerger et al.
Good morning, Your Honor. Shannon Sams for the sheriff.
Hi, Mr. Sams. I saw a proposed consent order come across my desk in this matter.
It's actually contested, Your Honor.
Oh, it is contested. Okay. And who do I have here on behalf of the contesting parties?
Good morning, Judge. I'm
Good morning, Your Honor.
Thai Investments.
Mr. Clark, did you say you're here on behalf of Thai Investments?
Yes, Judge.
And someone else started to speak who's also part of the protest.
This is James Knowles, One Source Investment Group.
Yes, sir. Mr.
Your
Nobles,
Honor,
are you an attorney or are you like a principal of One Source Investment Group?
I'm the principal of One Source Investment.
Okay. And I'm sorry, would someone else trying to get my attention?
yes, Your Honor. I'm Bobby Hill on behalf of the city of East Point.
Yes, sir, Mr. Hill. Okay. And Mr. Sams, if you could venture in a sentence or two to tell me the nature of is it a priority issue or what is the nature of the protest?
I believe the dispute is between Ty Investments and One Source Investment.
Yes, sir.
One Source Investment had the property under contract, and Ty Investments has an assignment from the owner at the time that assigned the rights.
Understood. Okay. Thank you, Mr. Sams.
Sure.
And then, I'm sorry. Yeah. Yes, and then position 7, Sheriff Labatt versus Stephen Kern.
Good morning, Your Honor. Adam Caskey for the sheriff.
Hi, Mr. Caskey. Are there any disputes in that one? I thought I saw an order from you as well.
Well, actually, I think the order you saw from us would have been for the other case we have on the calendar, for which Ms. Spiker is here. This case, I don't believe we had a dispute. The United States of America had made a claim. They on Monday withdrew that claim, or at least verbally gave me permission to present an order saying that they, or verbally and in writing, gave me permission to present an order saying they withdrew their claim. We sent a proposed consent order to Mr. and Ms. Kern. We have not heard back, but they are the only claimants at this point.
Okay. And I assume that if the sheriff were given authority, given that Mr. and Mrs. Kern are the only claimants, but they're not here, that the order that would be entered would say that the sheriff is entitled to the interpleader relief to pay the funds in to receive their attorney's fees, and then the remainder would sit until Mr. and Mrs. Kern decided to come and claim it.
Either that or we know where they are, so we could mail the check, but it's obviously up to Your Honor how you would prefer to handle it. They filed an answer. We couldn't get them personally served, so we ended up, I believe, tacking and mailing, and in response, and we publish, in response, they filed an answer.
Okay, thank you, Mr. Caskey. And then on to position 8, Sheriff Labatt versus Joan Livingston St. Romain.
That's our consent order case.
Okay, thank you, sir. Is anyone here on that case besides
Yes,
Mr.
Your
Caskey?
Honor. Harry Woodworth here for respondent, Irmont Village.
Okay, and have you had a chance to look over the consent order, and does it meet with your approval in terms of what you worked out with the sheriff's department?
Yeah, we agree. We have no objection to that being
Okay.
entered.
Okay, well, that one's easy, Mr. Woodworth. If that's the only reason that you're here, I can go ahead and tell you that I've already reviewed that order. I just had it confused if it was position 7 or 8, but it does appear to be in order, and I am going to go ahead and sign off on it when the hearing is complete. So,
Well, that's my goal, is to be as easy as possible, Your Honor. So, you have a good day.
thank you, Mr. Woodworth.
Thank you.
Okay, going back then to the beginning, Mr. Buddy, Holcomb's Crossing Homeowners Association versus Felicia Stanton. Please go ahead with your presentation, sir. I do have your proposed order here, so.
This is an action to collect unpaid homeowners assessments. The court issued an order for service by publication on February 13. The publication ran and no answer was filed within the required time frame. The amounts in our complaint are fully liquidated except for attorney's fees. As to the fees, I can testify that I'm attorney licensed to practice law in the state of Georgia in good standing. I've been admitted in the state for 10 years. I'm associated with the law firm Coulter and Sierra. The hourly rate we charge the association is $275 per hour, and the paralegals in our firm bill a rate of $115 per hour. In this matter, the association has incurred a total of $1,996.50 in attorney's fees and $760.24 in court costs and expenses through the date of today's hearing. I have reviewed the attorney fee statements that we submitted along with our motion for default judgment, and the fees incurred in this case are reasonable in light of the work done and are customary for the community association practice here in Atlanta. As the court can see from the proposed order, although the defendant did not file an answer, she did make a couple of partial payments this year. With those payments added, or excuse me, subtracted from the balance, the total amount is $2,009.83.
Okay. Thank you. I did have a chance to review the order. The record does indicate that service was completed by publication by an order from this court on February the 13th. The only slight wrinkle is that by my calculation, the deadline for the answer would have been April the 14th. And most significantly, the last day to open default as a matter of right would be today. And so what will happen is I will, it may be, in full disclosure, given that Ms. Stanton has contacted the court, it may be that she is making some effort to open that default today. If she does, then I will bring you back in for some sort of hearing. If she does not, then I will go ahead and enter the order tomorrow when it would be right for doing so.
Yes, Your Honor.
Okay. Thank you, sir. You may have a good day.
You have a great day as well, Your Honor.
Thank you. Anyone here on behalf of Citibank for position 2? Okay, besides Mr. Lopez. Okay. Keep sitting tight, sir. Anyone here on behalf of Lakeside at Crabapple Community Association? Okay, Villages of East Point versus Raymond Bell. Ms. Swain, my record indicates that Mr. Bell was served on March the 9th. And that the last day for him to have opened default as a matter of right would have been April the 23rd, and that no effort has been made to open default as of now. And therefore, Mr. Bell is in default in this matter. If you would like to briefly put forth your witnesses regarding the amount of the damages sought in your proposed order.
Absolutely, Your Honor. And Your Honor, defendant owns the property subject to restrictive covenants. The covenants required to pay assessments on time. Defendant failed to pay them on time. Moreover, he hasn't paid anything since September of 2021. So I have 3 witnesses to testify, actually. The first witness from the association to go over amounts owed for assessments and interest and other charges. Ms. Patel, and the next witness will be a representative from the Professional Debt Collection Agency Alliance, LLC. She'll go over the amounts incurred by the association in an attempt to collect from this owner, from delinquent owner, and lastly, I will be testifying myself regarding the attorney's fees. I'm going to call my first witness, Ms. Patel.
Ms. Patel, will you please raise your right hand? Do you swear the testimony that you're about to give the court will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you, ma'am. Go ahead, Ms. Swain.
Ms. Patel, please state your name for the record.
Daksha Patel.
And what is your affiliation with the Villages of East Point Homeowner Association?
I'm the regional manager for the association from the management company.
And does the association have a system for recording assessments, payments, and other charges?
Yes, ma'am.
Are you familiar with the system and how it works?
Yes.
And do you recognize the document marked as Plaintiff Exhibit A? I provided it.
Yes.
And what is it?
It's the homeowner's Mr. Bell's ledger.
And for which property?
3113 Beirut Circle.
East Point?
East Point, yes, I'm sorry, East Point, Georgia.
And who is the owner of this property?
Raymond Bell.
And is this ledger kept in the regular course of business?
Yes, it is.
Your Honor, plaintiff would like to have this document admitted as Plaintiff Exhibit A.
Go ahead, it's admitted.
Thank you. Based on this ledger, what are the monthly assessments owed to the association?
$199.15 are due per month.
How much does the defendant owe for assessments through April 29, 2025?
As of April 29, 2025, $8,035.92.
In addition to assessments, the association is also entitled to interest, calculated 7% per annum. What is the total amount interest accrued at 7%?
The defendant owes $245 in interest and late charges.
It should be more than $200.
I'm sorry. I am so sorry.
At 7% per annum.
Yes, yes. 7% for the interest and accrued late fees in the amount of $1,021.27.
Thank you so much. And the association is also seeking amounts for miscellaneous charges. What are
Yes.
these charges for and how much does the defendant owe in miscellaneous charges?
It is $245 in miscellaneous charges.
And what are their charges are for?
Their charges are for debt collection agency, which covers the cost of preparing the file and transferring it to Alliance.
Okay, thank you so much. And based on this ledger, were any payments made between September 1st, 2021 and April 29th, 2025?
No, the association has received no payments from the defendant since September 1st of 2021.
Thank you. And is the association owed anything for attorney's fees and cost of collection?
Yes, they are.
Thank you. No further question, Your Honor, for this witness.
Thank you, ma'am. You may be excused.
Thank you.
I call my next witness, Ms. Bird from Alliance.
Okay, Ms. Bird?
Ms. Bird, oh, I'm sorry, Your Honor.
No, that's okay. I can't find her on my screen, so I'm gonna let you go ahead.
Ms. Bird, can you raise your right hand? Do you swear and affirm to say the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you so much. Please state your name for the record.
Jessica Bird.
And where do you work, Ms. Bird?
I work for Alliance CAS, the professional debt collection agency.
And what is your position in Alliance, at Alliance?
I am the manager of compliance and risk.
And what type of services does Alliance provide?
We provide debt collection to community associations.
Has Alliance been contracted to provide collection services for amounts owed by Mr. Bell, Raymond Bell?
Yes, we have.
Does Alliance have a system for recording its fees and costs for specific collection matters?
We do.
Are you familiar with the system and how it works?
I am.
Do you recognize the document marked as Plaintiff Exhibit B?
Yes, I do.
And what is it?
This is the statement of account summary for Raymond Bell.
Is the statement of account kept in the regular course of business?
Yes, it is.
Your Honor, plaintiff moves to have this document admitted as Plaintiff Exhibit B.
It's admitted. Go ahead.
Does Alliance keep track of its fees and charges?
We do.
Can you please explain the administrative and monitoring charge?
Yes. That charge is for the tracking and management of all active collection files, including bankruptcy monitoring, title transfer monitoring, tax sale monitoring, and foreclosure sale monitoring.
And can you please explain the Recovery Operations Center charge?
Yes, that covers all active collection measures, including calls, emails, as well as skip tracing.
Based on this statement of account, what is the total amount of Alliance fees and costs being sought from the defendant?
That amount is $7,353.52.
And were these amounts actually incurred by the association?
Yes, that's my understanding.
And is it your understanding that the declaration authorizes the association to recover these amounts as costs owed to the association?
Yes.
No further question, Your Honor, for this witness.
Okay, thank you. You may be excused.
Thank you.
And Your Honor, we're also seeking reasonable attorney's fees and costs in this matter pursuant to the declaration in Georgia law. My name is Diana Swain. I'm a licensed attorney in the state of Georgia. I'm attorney for DS Law Firm. DS Law Firm has performed legal services on behalf of the Villages of East Point Homeowner Association. The account statement that I submitted as Plaintiff Exhibit C is in true and correct copy showing attorney's fees in this matter and the cost showing in the Exhibit D, which is maintained as a business record. The legal services rendered in this matter resulted in an attorney's fees of $2,550 and court cost of $631.72. These fees were actually incurred by the association. These amounts are reasonable considering the nature and complexity of this matter. And the DS Law Firm has expended a total of 12.8 hours on this case. Nothing further, Your Honor.
Okay. If you could just back up for a moment, I'm looking at your proposed order, and I think one of the numbers doesn't line up. Is your total number that's in the order still $19,844.08, or has that number changed?
It didn't change, Your Honor.
Okay, I thought you said a number for costs that was different than the $638.37 that is listed in your proposed order. That's the one that I was confused by.
One second. It's $631.72. The court cost.
Okay, the order that you have sent to me has a different number. It has a section for costs and it lists $638.37. And so what I'm going to ask you, you don't even need to submit a whole new order, but if you want to send me the table that you typically submit that has the dollar amounts exactly, because
Absolutely.
yeah, I don't want to enter an order that even if the dollar figure is correct at the end, it'll look like either I can't add or we'll have to do an updated order. And so if you'll just send us that table portion, we'll go ahead and finalize your order. You have made a sufficient showing in terms of entitlement. As I said, it is clear to the court that there is a default. And so I just need to make sure that my numbers are right. And then once I have an order that is updated, then I will get it on file for you. Okay, Ms. Swain, if you'll just email that to Mr. Freehoff. Okay.
I will do. Thank you so much, Your Honor. May I be excused?
Yes, thank you to you and your witnesses. You all may be excused.
Thank you so much.
Thank you.
Thank you.
Bridgestone, Mr. Moore.
Hey, good morning, Your Honor. How are you?
Hi, I'm doing fine, Mr. Moore. So my review of the file indicates that you guys got service on March the 3rd, that was timely filed by March the 10th, such that it relates back, and that the last date for Mr. Calloway to have opened default as a matter of right would have been April the 17th, and that has not occurred. So if you will take it from there in terms of the amounts that are sought, that would be helpful.
Certainly, Your Honor. The plaintiff is a homeowner association and the defendant owns a residence within the association, is bound by the covenants. One of the obligations is to pay outstanding assessments, which the owner has not done, which necessitated us filing this lawsuit. The amount of the assessments, which is liquidated that are past due, is $2,775. That's the amount in the complaint and the order. There's accrued interest on that amount, along with $1,131.75. And the plaintiff is also seeking, pursuant to the covenants and OCGA 44560E, to recover its reasonable attorney's fees actually incurred in bringing this action. The attorney's fees incurred were $2,090. I'll state in my place that I'm a senior partner at the law firm of Lazega & Johansson. I've been practicing for 33 years. I believe this is a reasonable fee to handle this matter, given my expertise and the work that was done on the file. Both the covenants and Georgia law provide for the association to recover their reasonable attorney's fees actually incurred. So we'd ask that the court award those fees. The total amounts broken down are on the proposed order that was submitted to the court. And we would ask that those amounts be entered.
And is that total amount $6,769.75?
It is, Your Honor.
Okay. As I said, I have reviewed the proposed order. I have reviewed the docket to confirm that there was in fact a default and that there's been no effort to open that default. And so you are entitled to the default judgment, and the amounts that you have presented appear appropriate to me and are properly supported. So I will go ahead and get that order on file for you later today.
Thank you, Your Honor. That's all I have.
Thank you, Mr. Moore. Have a good day.
You too. Bye-bye.
Okay. Mr. Sams, Sheriff Labatt versus, and actually it's not you, Mr. Sams, really. It's Mr. Clark and Mr. Nobles. Mr. Sams, for my benefit, can you just lay out the dollar figures for me very briefly, and then I will call on Mr. Clark and Mr. Nobles. Mr. Hill, quick question. You're here on behalf of the city of East Point as an interested party, but am I correct that no one is contesting your entitlement, or does the outcome of the dispute between Thai Investments and OneSource affect your recovery, sir?
I don't think so, Your Honor. I believe the city would have priority over any claims that the other parties would have.
Yeah, that's kind of what I thought. I just wanted to make sure you were of the same opinion, so I didn't have to bother you in terms of expecting to have to hear from you. Just wanted to make sure. Thank you, Mr. Hill. Mr. Sams?
Thank you.
Sure. So at issue is $24,860.83. I have filed a motion for interplea relief and sought attorney's fees and cost totaling $4,507.81 pursuant to 4845. If successful, that would leave $20,353.02. And I'm not sure what Mr. Hill's claim is for East Point.
Mr. Hill, do you know readily?
Yes, Ron. I don't have anyone here from the city, but I do have a certified copy of a delinquent tax notice.
Okay.
That states the current delinquency for the years of 2017 to 2013 is, sorry, give me one moment. $8,557.58.
8,557.58.
Yes, Your Honor.
Thank you, Mr. Hill. Mr. Sams, anything else?
That would leave $11,795.44, I believe.
Okay. And from there, Mr. Clark, Mr. Nobles. Mr. Clark, can you tell me what your position is on behalf of Ty Investments?
Sure. The property is owned by a trust, the Augustin Brown Trust, essentially, when it was sold at a tax sale. And Mr. Brown, is the trustee of that trust, assigned the ownership interest claim to the excess funds to Ty Investments. And so we're essentially claiming as the owner of the property on the time of the tax sale. It's fairly well established that after any liens that are against personal property are paid out, in which the city's taxes are both personal and in rem. So I think the city would have a valid claim to their lien. Anything left after the liens on the personalty are paid out would go to the owner of the property, which is the basis of our claim. The One Source Realty claim, I think I know what it's about, but I'm not sure. I mean, we filed a motion to strike their answer because it's filed on behalf of an LLC, but not filed by a lawyer. And obviously there's no lawyer here today representing the LLC, so we would object to a layperson representing that LLC here. I think that what they have is a contract to purchase the property before the trust obtained its interest in the real estate on June 27th, 2023. I believe One Source may have had a contract possibly with the prior owner before the trust owned it, who was Augustin Brown individually. But I don't see how that would account or amount to a lien against personal property. But so I'm really not quite sure what the basis of their claim is exactly, but we would object to their claim entirely because they haven't had a lawyer represent them.
Understood. Mr. excuse me, Mr. Nobles, at the beginning of the hearing, you'll recall that I asked you if you were an attorney or if you were a principal of One Source Investment Group. And the reason that I asked you that question is that it is an endless source of frustration for small business owners like yourself. But the law in Georgia is very clear that in magistrate court, an LLC can represent itself like an individual principal. But in superior court, which is where this case is pending and necessarily has to be pending because of the nature of the relief that is sought, an LLC, a corporation, an entity of that type has to be represented by a lawyer. And so there was a motion that was filed to strike your answer on the basis that you do not have an attorney, that One Source Investment Group is not represented by an attorney, and therefore the answer is not a valid filing. And for the same reasons, it is oftentimes I will try to let you tell me what your position is, but it is legally the court is limited in what it can consider that you would present because you are not an attorney. And so therefore you're not authorized by law to represent One Source Investment Group. Do you understand that, Mr. Nobles?
Yes, ma'am, I do.
Okay.
What
yes,
I'd
sir,
like
go
to
ahead.
do is ask for a continuance to find an attorney.
Okay. So if I were to do so, it would be very brief. And it would be a situation in which I would go ahead and allow the parties whose claims are not contested, to be, I would allow the sheriff to interplead the funds. And I would allow the city of East Point to take their claim, which I believe I understand does not affect the remainder 11,795.44. That would be a remaining claim between OneSource and Mr. Clark. Now, Mr. Clark, I'm sure you don't love that approach, but what are your thoughts about that, sir?
Well, Your Honor, we filed our motion to strike some time ago, and they've clearly been on notice that of our position. And I think everyone is charged with knowledge of the law, and they should have known that they need an attorney. And they could have hired one today. I mean, they put on their answer that their lawyer's name is Pavel Dorch. I emailed her more than a week ago to find out whether she'd be representing them in this case, and said she was not. So they've known they need, for the need of a lawyer, and just waiting until we get to the final hearing on this matter to raise this, I think, is a little tardy. But one thing if they asked for it ahead of the hearing, but they didn't.
Understood, Mr. Clark. Okay, so let me start with the easy part, which is that it does appear to me that the sheriff has done what is necessary to file this interpleader to secure service on interested parties, and that the sheriff's department is the sheriff's office, I'm sorry, is entitled to recover its attorney's fee. It's entitled to interpleader relief, and it's entitled to recover its attorney's fees in the amount of $4,507.81. It also appears to me, based on consent and no objection, that the city of East Point is entitled to recover $8,557.58. In terms of that, leaves a remaining amount of $11,795.44. It appears to me that OneSource Investment Group is not represented by counsel, and therefore their answer is a nullity under the law, and therefore the motion to strike is due to be granted. If OneSource Investment Group's answer is struck, and they are legally not present at this hearing, in that there is no entity or person that's authorized to represent OneSource Investment Group present here today, then that would mean that Ty Investment LLC would be entitled to recover on their claim. Mr. Clark, is the claim by Ty Investments for the entirety of the remainder after the payment to the city of East Point and the payment for attorney's fees to the sheriff?
Yes, Your Honor, it's for all the remaining balance.
Okay. So what I am going to do is ask Mr. Sams, if you can. Did you already send me a proposed order? I thought
I did, but I'm happy to modify it based on the fund.
If you can modify the order outlining what I've just stated, the only caveat, Mr. Clark, that I'm going to undertake is this. I'm going to enter that order, but I'm going to order the disbursement of funds to the sheriff. I'm going to order disbursement of funds to the city of East Point, and I'm going to hold the disbursement to Ty Investment Group for a period of time to determine if there's any appeal or anything else like that might occur. And assuming that there is not, then I will order the disbursement of those funds to Ty Investments. Does everybody understand that ruling? Anything else that you would like to make note of or put on the record, Mr. Clark?
I just want to clarify the time of the holding period.
It's gonna probably be about 32 days, 33 days.
Okay, just for the appeal period to run?
Yes, sir.
I understand.
I'll look at a calendar and give an exact date. What I'll do.
I understand the intent.
Yes. Fine. Mr. Nobles, I understand you're probably frustrated by this outcome, but it is my hope that you at least understand the outcome, even if you don't like it. Do you have a question or anything for me that I can try to address for you, sir?
No, I understand what you're saying. Actually, I didn't receive a notice of this in the mail. I think it was someone from Mr. Sam's office, or Miss Jackson, who reached out to me a couple of weeks ago and advised that I needed to file a response, but she never told me that I needed an attorney. And I understand 100% that ignorance of the law is no excuse for it. but I wasn't aware that I needed an attorney. So when I tried to file it, it said online, it said that an attorney had to file it online. So
Okay.
that's why I chose Attorney Dorsch filed it for me. Had I known I needed an attorney, I would have gotten one. So yeah, I'm fine with it. I'm good with your appeal. I will have an attorney who will file an appeal on this for me. So I do appreciate you for doing that.
Okay, understood. So Mr. Sams, if you can send me something that generally outlines that ruling, I will get it on file for you. And then the sheriff can at least pay their money in and go on to their other cases, okay?
And real quick, before,
Yes, sir.
how can I make sure that I receive the notice regarding that appeal and the steps I need to follow to file that appeal?
So the order that I'm going to enter, because you are pro se, will be mailed to you. If you have an email address that you can provide to Mr. Freehoff, he can put you into the Odyssey system as a service contact by email, and then you
Okay.
would get email notices of our filings.
All right, I'm sorry, who is Mr. Freehoff?
Mr. Freehoff is identified on the Zoom as my staff attorney, and if you
Okay.
know how to work the chat,
Yes, ma'am.
you
Yep.
can, right, you can send him a chat in the Zoom to let him know what your email address is. And when
Okay.
we file this order, we will add you as a service contact.
All right, thank you, ma'am.
Thank you. Everyone that's here for that matter can be excused.
All right. Thank you, Your Honor.
Thank you
Thank
all.
you,
Thank
Your Honor.
you.
Okay, and Mr. Caskey, Sheriff Labatt versus Stephen Kern and Chandra Kern. That was the one that I had the consent order on.
Actually, it's the Livingston case, and Ms. Spiker, I believe, is still on for that one.
I apologize, I apologize. Okay, but the one with the Kerns, as we had discussed, is the one that the only entities that the sheriff believes has a claim are the Kerns, and that they did file an answer. The question is whether we send them the funds that are the remainder, or whether we hold those funds until they make some sort of claim.
That's correct. And if you prefer, Your Honor, we can email them again and ask them to confirm they want it mailed, give them a period of time. And if they prefer it picked up, maybe give them to the end of the week.
I think that's fine. I would certainly rather have that money go to them directly rather than make them have to go through more procedural hurdles to access the funds if it appears that those funds are rightly theirs. So let's if you can send me a proposed order that does that, and then I will hold the order until the end of the week to see if we hear from the Kerns in terms of directing either to us or confirming to you that their address is correct and they want the funds mailed to them, in which case I'll go ahead and enter an order to that effect. If we don't hear from them, then we still would probably mail the order to the Kerns so that they would be aware that those funds are being held.
Okay.
Okay. Thank you, Mr.
All
Caskey.
right, thank you.
Now, moving on, Ms. Spiker, for your patience. And this is the Sheriff Labatt versus Joan Livingston St. Romain.
Yes, Your Honor, I represent respondent Joan Livingston St. Romain.
Okay.
I've remained on just because I didn't say anything earlier when you referred to the case, and I agree with the proposed order, final order.
Okay. Thank you so much, Ms. Spiker. I did have a chance to review that order. Again, I was confusing the 6, 7, and 8 positions, but I have them straight now, I think. In any event, Mr. Caskey's order, as I reviewed it, appeared to be fine. And the sheriff is entitled to the interpleader relief that is sought, and it doesn't appear as if there are significant competing interests of any kind. And so the remainder after the attorney's fees are paid and interpleader relief allowed to Mr. Caskey's client, the sheriff, would go to Ms. Livingston St. Romain. And I don't remember, is there an address? Is it to be sent to you, Ms. Spiker?
I'm to pick it up in person.
Okay, excellent. Well, that certainly makes everybody's lives easier. We don't want to, sadly, nobody trusts the mail anymore.
That's correct.
Anything else that y'all need from me, Mr. Caskey or Ms. Spiker?
Oh, Your Honor.
Okay, thank you very much. Have a
Thank you.
good day.
You too.
Okay, Mr. Lopez. The reason that I asked you to stay until the end of the hearing is this matter, as you know, was set for hearing at 9 o'clock this morning. You were present. My notices of hearing state quite clearly that if you fail to appear, that the matter will be subject to dismissal. And no one appeared on behalf of Citibank, and so I'm going to dismiss this lawsuit. Now, I don't want to make any representations to you whatsoever. I don't know anything about the timing of the filing by Citibank, and so I don't know if Citibank may come back and try to file against you again. I don't know any of that, and so I don't want to make you think that they could never come back on this case. But at least for now, I am dismissing this case because they failed to appear. And so this case will no longer exist, Mr. Lopez. Do you have any questions for me that I can answer? I may not be able to answer them because it may be unfair legal advice, but.
Your Honor, I'm
Okay,
his wife. I have a question.
thank you very much.
Okay, Ms. Lopez, you had a question?
Hey, yeah, he's not in a good area, so I just wanted to make sure that I was present as well, Your Honor.
Yes, ma'am.
Thank you. We appreciate your patience. I just have a question. I know you said that we cannot be guaranteed any recourse in the future, but what exactly does this dismissal mean just as far as for our record keeping?
So I can't give you legal advice, but I can tell you that the reason Citibank filed a lawsuit against you is that the next step in their effort to attempt to recover what they claim is owed is to file a lawsuit and get a judgment that they could then attempt to recover against you. But this lawsuit is being dismissed. So that means they do not have a judgment. Now, the reason I said, I mean, it's possible whatever the timing is, they might try to refile and then later get, and get a judgment against you in a later lawsuit. My point was simply to say the fact that I'm dismissing this lawsuit doesn't affect any future lawsuit. But I wanted to make sure that the purpose of them filing is to try and get a judgment against Mr. Lopez for that amount. And they can't get a judgment today because their claim is being dismissed. So does that make better sense, Ms. Lopez?
Yes, ma'am. May I please message Mr. Freehoff our email address to get that in electronic form as well?
Yes. So what'll happen, you're free to send Mr. Freehoff in the chat your email address. What will happen is because the case is closed, we're not going to add you as a service contact, but we will send you a courtesy copy of the order that we're going to enter that dismisses this case.
Okay. Perfect.
Okay.
To the email. Thank you.
Yes, ma'am. So if you'll just send that to Mr. Freehoff in the chat, then we will send you a copy. And you both
We appreciate your time. Thank you.
Thank you. You're both free to be excused. Have a good day.
Thank you.
Ms. Lopez.
Yes, I'm here.
We're the only two left now. So I'm waiting for you to send it to me. And
I'm sending it now. I got you.
I'm going to confirm what I'm seeing. That is QIANA Jacobs. That's JACOBS 1 at gmail.com.
Got it.
Okay.
And I'm writing yours down as well. Hold on one second. FultonCountyGA.gov. Okay, Mr. Freehoff, we appreciate you.
Okay, thank you very much. And you'd like the order of dismissal in this case emailed to you at the KianaJacobs1@gmail.com.
Yes, sir. That's my maiden name. We're newlyweds.
That's fine. I will address in the body the email to both yourself and Mr. Lopez so that it's clear that it's being sent to him as well.
Excellent. Thank you.
All right. Thank you. Have a great day. I'm glad you had a good outcome today.
Thank you.
All right. Bye-bye.